Hello everybody, welcome to our CMA classes. This is Soumya Santosh, a CMA finalist, and today we are going to start our another chapter of Corporate and Economic Law for CA final and CMA final students, and the topic is going to be Competition Act as per 2002. So first of all, we have to understand why Competition Act was introduced. The main motive was to promote the competition in India or to not to promote the competition in India. So I'll tell you I'll tell you in a very simple line that Competition Act was introduced to promote the competition in India first of all, okay, and to prohibit that activity which was giving adverse impact, which means the negative impact on the competition in the domestic market, which means to increase the economic flow of competition. I mean, there should be a fair and healthy competition in the environment. Let me give an example. For example, there is a monopoly market. Okay, what happens in monopoly market? There is only one seller, and that seller is going to determine the price of that product, because he is the ultimate seller in the market and he is having the right to increase the price as there is so much demand and the supply is only one. In that case, the market is going to, what is going to happen? The adverse impact, because the demand is increased and price is also increased, right? And there is no another competitor in the market. Okay, so these are some of the activities which give the adverse impact in the economy, which indirectly decrease the flow of domestic market. So let's find out what are the things written in this act. The Competition Act, as per the law, was introduced in 2002. Okay, a significant legal instrument in India that supervises and manages commercial competition. It came into existence to replace monopolies, as we know what is the meaning of monopolies, and restrictive trade practices as per 1969 Act, which was outdated and no longer viable now. In today's time, it's outdated. Okay, the main purpose of Competition Act 2002 is to discourage and to prevent activity that negatively impact competition within the Indian market. And let me give another example. For example, the China is promoting, right? From China we are importing goods, and the goods price is actually very less. It's really very less than the actual price which is actually made in the article which is made in India, or the same product which is available in India. For example, if the product cost is 100 rupees, then they are selling it for 40 rupees, right? So what is going to happen? Our domestic seller, we are not promoting our domestic seller, right? Day by day the domestic seller are going to reduce as there is no sale, right? The sale range is decreased from so many years of domestic market. So that was the reason this act was introduced. There are definitely some other reasons also, but this was also one of the point covered in this part. So let's go for it. Why do we need competition law? To uphold the free enterprise. The competition law has been called the Magna Carta of free enterprise. Okay. Second point, securities against the market distortion, which says domination position, right? Who is having the dominant position? Example is monopoly, right? There is a construct risk of various people resorting to the market distortion and abusing their domestic position to resort to the anti-competitive activities. Thus, competition laws are required to ensure that the market is safe from the various distortions. Third point says they also aid in the promotion of domestic industries, right? Like our PM Shri Narendra Modi ji sir is saying made in India, right? He is promoting making India products, right? The products which are actually made in India, make in India. And being a citizen of our country, India, we have to promote our product firstly. Okay, then we should, if those products are not available in our domestic market, in our country, in that case we can go for like import that product or goods from outside. Okay, so this is promoting the domestic industries well. Okay, the competition laws are required to ensure that the domestic industry do not get suppressed with an increase in globalization. They play quintessential role in determining the viability of domestic industries. However, to keep the Indian competitive law updated with the business of the digital world, which include not many assets, the Indian government has established a competition law review committee for this. Okay, so these are the things which are saying why we need Competition Act. Okay, so the act seeks to prevent monopolies and also to prevent unnecessary intervention by the government. The main objective of Competition 2002 Act is to promote the framework for the establishment of the Competition Commission. Okay, so in this chapter we are going to understand one more thing which is related to Competition Committee. Okay, why this committee is formed and what is the main objective of this committee. Apart from this, the other objective is going to prevent the monopolies. Definitely we know this. To promote the competition in the market, which means a fair competition should be in the domestic market. Okay, to protect the freedom of trade for the participant individual and entities in the market, and to protect the interest of the consumer, right? The consumer should not be exploited, right? Some things while making the product, the consumer is the ultimate person who is going to consume the product, right? So making the product, we have to keep the actual need of consumer. Okay, so these are the main objective of Competition Act. First is to establish the Competition Commission to provide framework, right? Second, to promote a very healthy competition in the market, monopolist rokna. Third, freedom of trade policies and individual and entities in the market, and protect the interest of the consumers. Okay, let's go for the other part. Competition Act 2002 was enabled by the Parliament of the India and govern Indian competition law. It replaced this part. Okay, and under this legislation, the Competition Commission of India was established to prevent the activities that have adverse impact on the competition of India. This extends to the whole of India, including J&K, Jammu and Kashmir. It is tool to implement and enforce competition policy and to prevent and punish anti-competitive business practices by the firm and unnecessary government interference in the market. Okay, so this is the main motive of implementing this. Okay, to prevent the punish anti-competitive business practices by the firm and also unnecessary government interference, okay, in the market. So competition law is equally applicable on written and as well as oral agreement. There was a question in SCAN. I have seen one question. What if there was only an oral agreement done between the enterprises? Is there would be a valid competition law among them, Competition Act? Yes. Whether it is a written agreement or an oral agreement, in both cases that is going to be valid. Okay, so the Competition is act of a seller individually seeking to acquire the patronage of buyer in order to achieve profit or market share. Competition was enabled by the Parliament of the. So these are the simple things which I have already said. Okay, now we have to understand up to this what were the main thing, what is the why was the Competition Act formed, implementation, what was the reason behind of implementation of Competition Act. Now we know this. Okay, what was the objective, now we know this. Okay, now let's go for the other part of anti-competitive agreement. Now we have to understand what is this. Okay, enterprise, person, associate of enterprise or a person including cartel shall not enter into agreement in respect of production, supply, distribution, storage, acquisition, control of goods and provision of service. So can I write this? Okay, any enterprise. Okay, let me write it. Okay, any enterprise, any person, any association of enterprise or person. Okay, so can I write any enterprise, any person or any association of enterprise or person, okay, including cartel, shall not, they shall not enter into agreement, okay, in which is related to what, which is related to production, which is related to supply, which is related to distribution, which is related to storage, which is related to acquisition, which is related to control of goods and supply, okay. GNS, CGNS, production, supply, distribution, storage, acquisition, and which is related to control of goods or services. So these enterprises, these persons cannot enter into any agreement which is prohibiting these activities, okay. Which activities? The production, supply, distribution, acquisition, storage, and control on purchase goods or services, okay, which cause or likely to cause an abbreviative adverse impact on the competition India, okay. Such agreement would consequently be considered void, okay. If any person, if any enterprise enters in agreement related to these terms, okay, this is going to be a void agreement in that case, okay. That agreement is not going to be valid in this case, okay. Agreement which would be considered to have appreciable adverse impact would be those agreement. Now we are going to understand which agreement they are talking about. Directly or indirectly determine the sale purchase price, okay. So either these people, the enterprise and the person are going for an agreement, okay, which is related to production, supply and all, okay, and in that agreement they are going to determine the price of purchase price or sale price, okay. First thing, to limit the control, production, supply, market, technical development, investment and provision of these services, okay. Share the market or the source of production or provision of service by allocation of inter alia geographical area of market and nature of goods. They are, what are they doing? On the basis of geographical area, on the basis of nature of goods or the number of consumer or other similar way, they are discriminating the market, okay. They are making the allocation of those things, okay. Last, directly and indirectly result in bid riding or collusive bidding, okay. In these cases, if any of the enterprise, any of the person are going for an agreement which the agreement is related to production, supply, distribution, acquisition, storage and control on provision of services and goods, and what are the agreement related to? The agreement is related to control the price. Which price? The sale price, the production price, the purchase price and the sale price, okay. Related to control, limit the control production, supply and all, okay. Market, technical development and all, okay. Related to production, provision of service, allocation of inter alia geographical area and all, and which directly or indirectly gave the bid riding and collusive bidding, okay. These are the things which are included in anti-competitive agreement. Now let's go for the types of anti-competitive agreement. There are two types of anti-competitive agreement: horizontal anti-competitive agreement, second is going to be the vertical, okay. What is now the difference between these two? When the agreement is entered between the enterprise or person, okay, in the same level, okay, in the same level of supply chain, okay, that is going to be horizontal, as the thing say, as the word say, horizontal. So that is done in the same supply chain, okay. Hope so this part was clear. Let's go for it now. They are the agreement between the parties in the same line of the production, okay. Horizontal anti-competitive agreement is entered between the enterprise and the person operating at the same level in the supply chain. Horizontal anti-competitive agreement is presumed to have the appreciable adverse effect on the competition. And what is going to be the example? Let's go for some of the example, we'll get an idea. Example of horizontal anti-competitive agreement could be an agreement between the manufacturer, agreement between the distributors. Horizontal agreement are presumed to have appreciable adverse effect on the competition if they are directly or indirectly, again same thing is written here, okay. Let me say it again. There are two types of anti-competitive agreement, okay. Now we know the meaning of anti-competitive agreement. Two types of horizontal and vertical. Horizontal, when it is done in the same line of ठीक है, same supply distribution chain, ठीक है. When it is done in the same line, in that case that is going to be the horizontal, and it is done between which people, the enterprise and the person, right. And what is going to be determined in that agreement, same thing which was written in the anti agreement, ठीक है. So that is going to be the same thing, which is directly indirectly purchase, ठीक है, और कंट्रोल टेक्निकल डेवलपमेंट, शेयर और डिवाइड द मार्केट, और indulge in bid writing and collusive bidding. Hope so this part was clear. Now let's go for some of the types of horizontal, which is price fixing agreement, limiting or controlling the production and investment, market allocation and sharing, and bid writing and collusive bidding. I haven't defined them, okay, in our book. We have majorly talking about the vertical anti-competitive types. So let's go for the vertical anti-competitive agreement now. What I said, that was the horizontal was in the same line, right. Now the vertical is going to be the opposite, right, which means comparison between different people. Okay, so let's go for it. Check out what is written here. The vertical anti-competitive agreement are entered between two or more companies, each of which operate at a different level of production, right. In the horizontal anti-competitive agreement, what happens, the comparison was done at the same level of production, right, in the same level of supply chain, right. And here the agreement is between whom, between two or more companies, right, which operates at a very different level of production, distribution chain, and related to condition under which the parties may purchase, sell, resell certain goods or services. Let's go for some of the example. Okay, so an agreement between manufacturer and seller, or between producer or wholesaler, or between producers or wholesalers and retailers. So this was the example. Let's go for the types here. So what is tie-in agreement? There are 4-5 different types. Let me read the name first. They are tie-in agreement, exclusive supply arrangement, exclusive distribution arrangement, refusal to deal, and resale price method. Okay, so let's go for it now one by one. What is, now with a simple name we can simply know what is what could be the definition of these terms, right. So as per tie-in agreement, what is written, imposition and condition of purchase of goods, to purchase some goods and thus selling goods which is not of purchaser's choice. Okay, so here the seller is going to sell the goods, right. Ultimately the decision making is in the hand of seller, right, and the seller is simply providing only some particular products, some particular goods. Let me read it again. Imposing a condition on the purchaser of goods. So as per the customers, as per the purchaser's choice, he cannot do anything. Okay, condition, imposing the condition on the purchase of goods to purchase some other goods, and thus selling goods which is not purchaser's choice. Let's go for some example. For example, requiring a person to keep FD with the bank while offering him a locker. Okay, requiring a stabilizer to be bought along with the refrigerator. Okay, this is some of the example. Okay, so in this case, according to tie-in agreement, which says the choice is not in hand of purchaser. Okay, the seller is going to give the product, give the goods to the seller not as per his choice. Okay, so let's go for the exclusive supply arrangement. As the name says, exclusive supply agreement. Let's go for what are they have written here in the an agreement restricting the purchase in course of trade from acquiring the goods of any sellers, goods of any other seller, which means restricting a purchasing in course of his trade from dealing in any goods other than those of seller. Let me read it again, where agreement is restricting the purchase in course of trade. Okay, this agreement is actually restricting the purchase in which is done in daily trade, okay, from acquiring the goods of any other seller. So that purchaser can only purchase some goods from simple one person, right. So here restricting a purchaser in course of his trade from dealing in any goods other than those of the seller. Let's go for the third, exclusive distribution arrangement, agreement to limit or restrict the supply, output or supply of any goods to any market, which means limiting, restricting of supply of goods or allocate any area or market for the sale of goods. Okay, they are restricting here the supply of goods. Okay, in earlier it was a purchase of goods. Okay, let's go for the refusal to deal, restricting by any method any person, class of person to whom goods are sold. Okay, so up to some particular limit we are going to restrict that these person or this class of person cannot purchase this good, or these products cannot be sold to this particular person. Okay, resale price method, selling goods with a condition to resale at the stipulated prices, which means this goods can only be sold to you if you are going to resale these goods. Okay, so for example, for normally consumer, it's not going to be possible that we are ultimately purchasing the goods to resale it. Okay, we are purchasing it to consume it. Okay, so being a consumer, it's not possible to resell the product every time. Okay, which is not actually possible. Okay, so these are the different types of vertical anti agreement. They are tie-in agreement, exclusive supply arrangement, exclusive distribution agreement, and refusal to deal, and last resale price maintenance. Let's go for some of the salient feature of Competition Act 2002, which covers prohibition of anti-competitive agreement. Right? We know the meaning of anti-competitive agreement and the types, and what are the things which is again in the types of the anti-competitive agreement. Okay, so to prohibit it of abuse of dominance, we know this now, and regulation of combination, acquisition, merger and amalgamation of certain size. If it is going to what interest in the public, okay, if it is going to give the public interest according to public interest, if it is going to give the beneficial to the public, in that case acquisition, merger, amalgamation is going to happen. Okay, establishment of Competition Commission of India, power and function of Competition and Commission of India. So these two parts are related. So they are some salient feature of Competition Act, and they are to prohibit the anti-competitive agreement. First of all, to prohibit the abuse of dominance position, dominant power. Okay, third was of what, to regulate the combination of acquisition, merger and all. Okay, and last was of establishment of Competition Commission of India. So now we know what is the anti-agreement, now we know the abuse of dominant position, what is combination, okay, and Competition Commission of India. So let's go for 3 and 4 point here. As per the act of combination is defined in the term which leads to acquisition of merger, but should such combination cross the limit as put forth by the act, then the parties involved would under the scrutiny of the Competition Commission of India. Okay, so I'll tell you there are some limit, okay, which is prescribed by the Competition Act. So that limit, if they are crossing or if they are in that limit, in that case only they can go for the combination, otherwise cannot. Okay, so what is Competition Commission in India? The Competition Commission in India is independent body with the power to enter into contract, and should the contract be broken, they can sue the party involved. Okay, so the commission consists of maximum 6 members who are tasked with sustaining and promoting interests of the consumer in order to foster an ideal environment for the economic competition. Okay, so the Competition Commission is going to keep some things which should be followed in the market. Okay, so they are going to take over the market and find out whether the they is fair involved in the market or not. Okay, two of the main feature of the Competition Act 2002 is to framework it provides of establishment of Competition Commission, and tool it to provide to anti-competitive purchase and to promote positive competition in the market. So can I say the main feature of Competition Act definitely is going to be establishment of Competition Commission, right? This was also in the Salient feature, one of the Salient feature, right? And it is going to prevent anti-competition practices, which we already read in the Salient features, right? And which is going to give the positive competition in the Indian market. Okay, so let's go for the some of the other definition which is going to be covered here. We should know what is the meaning of them. Okay, acquisition is defined as the direct or indirect agreement to acquire shares, voting right, or the control of asset over any enterprise. Okay, so they are about the agreement to acquire shares, voting right, or control of the asset over the enterprise. What is cartel? An association of producers, sellers who limit control distribution, sale, promotion on goods through an arrangement previously made. Position, which means they are talking about the dominant position here. So I am not going to read this, but let's go for the fourth point. Predatory pricing. Predatory pricing is where the price of goods and services are reduced to below the cost of production in order to eliminate the competition in the market. Okay, so rule of reason, the interpretation of activity on the basis of business justification, market impact on the competition and other consumers. They are the basic definition which we should know. Okay, so Competition Commission of India, and let's go for the function and role of it, which eliminate practice which adverse impact, right, which eliminate the practice adverse to the competition, which ensure the freedom of trade in market, which promote and sustain the competition, healthy competition in the market, to protect the interest of the consumer and give opinion on the competition issues, and to undertake the capability building and competition advocacy. So these are the main function of Competition Commission of India. So let's go for it now. What is the Competition Commission saying? Competition Commission of India is established under Competition Act 2002. It is statutory body that has power to govern and enforce the Competition Act, including penalties. It was established when the need for healthy competitive environment became necessary for liberalization under the Vajpayee government. So this was formed under which government? Vajpayee government. Okay, this could come in our MCQ. So this was formed under Vajpayee government. Okay, and why it was made? When it was actually established when the need for healthy competition environment became necessary in the economy. Okay, so hope so up to this it was clear to you. Let's go for the other part. The act established a commission which is duty bound to protect the interest of free and fair competition, including the process of competition, and as a consequences protect the interest of consumer. Okay, broadly the commission duty is to prohibit the agreement or practices that have or likely to have appreciable adverse effect on the competition in the India, which is simply saying about the anti-agreement, right? Or what? There were two types of horizontal and vertical. Let's go for it now. So they are saying whichever is going to give the adverse effect in the competition in the market of India, they are going to prohibit that agreement, which is related to anti-agreement, right? So can I write it? Yes. So that this part, let me take the another color. Let me take it. Okay, to prohibit the anti-agreement, right? So let me write it here. They are talking about the anti-agreement. Okay, so second thing, I'll tell you one more thing. These things are same thing which we already read in the Competition Act, the Salient features and some other part of Competition Act. Okay, so in these Competition Commission is made while those things are kept in mind. Okay, so these Competition Commission are going to focus on those points which we have already covered. Okay, so let's go for it now, which is saying which is going to prohibit the anti-agreement, right? Second is saying to prohibit the abuse of dominance in the market. Monopoly, can I say monopoly? Can I write it? Monopoly. Okay, okay. Let's go for the third, to prohibit acquisition, right? A merger amalgamation between enterprise which are likely to appreciate the adverse effect on the competition in the market. Okay, earlier we read that some companies, some enterprise can go for the combination of what? Merger, amalgamation. Okay, so right now we are reading they are going to prohibit it, but they are going to prohibit it in which case? They are going to prohibit it if that is going to give the adverse effect on the competition, otherwise it's not going to prohibit that agreement. Okay, so can I say there are 3 points? First, they are going to prohibit it. The commission, which commission? This competition commission is going to prohibit 3 part, right? First, anti-agreement, right? Second, monopoly, dominance wala, okay, to abuse of dominance in the market, and third, to prohibit the combinations. Okay, so can I write combination here? And but this combination is only going to happen, this prohibition of combination is only going to happen if it is going to give the adverse effect on competition in the market, otherwise no prohibition is going to happen. Okay, so let's go for the composition of committee. Which committee? The competition committee of India. Okay, how many members are going to be there? Okay, the commission used to consist of 1 chair member. Okay, so there should be 1 chair member, 2 minimum member, and other maximum is going to be 6 member. So let me read it. Let me write it. 1 chair member, right? And 2 minimum members, and 6 is going to be the maximum members. This has further been reduced to 3 member and 1 chairperson by cabinet. This move was taken to produce faster turnaround in hearing and speedier approval, thereby stimulating the business process of corporates and resulting in greater employment opportunity in the countries. Okay, this is going to give the greater employment opportunity in the country, and the chairperson definitely is going to be the member. The chairperson and the member are going to be the full time members. Okay, eligibility of the commission: the chairperson and other members shall person of ability to integrity and who has been or qualified to be judge of high court or has special knowledge and professional experience of not less than 50 years in international trade, economy, business, commerce, law, finance, accountancy, management, industry, public affair, administration, or in any other matter which in opinion of CG may be useful to the commission. So this was the main purpose of forming the competition commission, and we know what is the composition of what is going to be the minimum and maximum number. Okay, and what is going to be the ability, which is related to knowledge and experience of the members and chairperson of the competition commission. Okay, so let's go for the functions. To ensure the benefit and welfare of the consumer. Okay, so they are going for to give the benefit to the welfare of the consumer and accelerate an inclusive economic growth through ensuring fair and healthy competition in the economic activity of nation, ensuring the efficient utilization of national resources through the exclusion of competitive policies. The commission also undertakes the competitive advocacy. It is also to antitrust for the small organization. Okay, and the competition commission will also scrutinize any foreign company that enters the Indian market through merger amalgamation that abides by the Indian competition law. CCI also ensure interaction and cooperation with other regulation authority in economy. This will ensure the securitization regulatory law and agreeable with the competitive laws. It also acts as business facilitator by ensuring that a few firms do not establish dominance in the market and there are peaceful coexistence between the small and large enterprise. Okay, so what are they focusing about? They are focusing on the welfare of the consumer. Okay, they are keeping some point for the welfare of consumer, right, which means the product should be made of quality, best quality, and it should be easily availability should be of product should be in the market, right. And they are going to focus on the economic growth, which means GDP, right, which is going to give the positive impact on our development of the country, okay, as India is a developing country. Okay, third point is about the utilization of resources, which means sustainable development, right? Sustainable reporting is also kept here. Okay, fourth point, under the competitive advocacy, commission also undertakes some competitive advocacy, and they are also going to subburdenment for the small organization. They are going to remove those things. Okay, for small organization, for small businessmen, they are going to help them. Okay, and for their help, they are going to eliminate or making availability of resources at very reasonable cost. They are going to help them in different ways. Okay, and other things, for those foreign company, those who are going to merge with Indian company, so some merger cannot be possible. Okay, and interacting, they are also taking role as business facilitator. Okay, medium. Okay, so let's go for some of the challenges faced by CCI. The constant and continuous change in by way of business are undertaken, and the involving antitrust issue is providing to significant challenge by the this is going to be one of the challenge, which means continuous change in business is one of the challenge faced by the CCI. Okay, so they are having difficult to identify or give what should be the they cannot give the proper guidance to the business in that case. Okay, the merging business model are based on the digital economy and e-commerce proves to be problem for the CCI, as the current commission laws talk only of the asset and turnover. Okay, as we know, the commission this committee was formed earlier, right? So, and India is now digitalized. Okay, let's go back, take example about the last 10 years. At that time, India was not digitalized. So, this is becoming one of the challenge for the committee. Okay, number of benches of CCI has to be increased to pronounce judgment and more speedily on the competition cases. This is one of the problem which is faced by the number of judges should be increased. Okay, so government should keep this thing in mind. Okay, so that employment could also increase, right? So, these are the challenges, these are the functions of CCI. Let's go for the fourth point, the inclusion of the parameter in competition and antitrust laws such as data ability network effect is important to ensure the competition, which is also related to digital economy. Okay, let's go for the review of order of commission now. Any person aggrieved by the order of commission, can they go for appeal? Okay, so they can go to appeal to which authority? We are going to read it. Any person aggrieved by the order of whom the commission can apply to the commission for review of its order within 30 days. Okay, within 30 days from the order of that commission. Okay, hope so this part was clear to you. Okay, any aggrieved party can go to the next 30 days from the order, they can go to the commission and entertain a review application after expiry of 30 days. If it is satisfied the applicant was prevented by the sufficient cause from preferring the application in time, no order shall be modified in that case or set aside, or without giving you an opportunity of being heard to the person in whose favor the order is given, and Director General where he was party in the proceeding. So, let's go for the appeal now. Okay, simply they are saying within 30 days of order they can go for the appeal. Okay, and the appeal can be done to the Supreme Court. Okay, let's go for it now. Any person aggrieved by any decision or any order of the commission may file an appeal within next 60 days. Okay, within next 60 days to the Supreme Court. Earlier we were talking about the commission. Okay, now we are talking about the from if they are not satisfied by their decision, then they can definitely go for further 60 days. Within next 50 days they can go for the Supreme Court. Okay, from the date of communication of order, decision or order by the commission, no appeal shall be lie against any decision or order of commission made with the consent of the parties. So, what is going to be the penalty? If any person fails to comply with the order or direction of the commission, shall be punishable with fine which may extend to 1 lakh. Okay, and non-compliance occurrence will be going for maximum penalty of 10 crore. If any person does not comply with the order or direction issued or failed pay fine imposed, in that case that is going to be extended up to 25 crore and imprisonment for 3 years. Okay, let's go for the some of the power of central government to exempt under Competition Act 2002. The CGMA by notification examine from the application of Competition Act 2002 or any provision thereof such period it may specify in such notification as any class of enterprise with exemption they with notification they can exempt these class of companies. Okay, so they are any class of enterprise if exemption is necessary interest of security of state or public interest. Okay, or any act agreement arising out accordance with the obligation assumed by the India under the treaty agreement or convention with any other country. Okay, and any enterprise which perform sovereign function on behalf of central government or the state government. So these people can be exempted. Okay, so this was the power of central government. Let's go for the last point, which is saying the regulation of merger and acquisition. This is going to the last point. Okay, so prohibits and voids any combination which cause or likely to cause an appreciation adverse effect on competition within the relevant market in India. The following threshold apply for the determining whether the merger acquisition became combination subject to the scrutiny or not. Okay, so there are some limit. They are the threshold value of asset. Again, the threshold value of asset turnover mentioned under section 5 of the Competition Act relating to combination and threshold allowing exemption from the notification based on the asset and turnover. Enterprise have been exempted from being parties in the following situation where the value of asset being acquired, taken control or merger or amalgamated is not more than 450 crore in the India. Okay, so the value of asset is not more than 450. Okay, it's not more than 450 crore in India. So what about the turnover? Turnover should not be more than 120 rupees 1250 crore. Okay, 1250 crore. Okay, so hope so this point was clear. Acquisition of the control by person over an enterprise when such person has already indirect control over another enterprise, engage in production, distribution and trading similar identifiable substitutable goods or provision of similar identifiable substitute. These are simple things. Okay, in case where a portion of enterprise division business is being acquired, taken control or merged amalgamated with another enterprise, the value of asset of said portion division business threshold will be calculated on the relevant asset and turnover. Okay, so this was the last point, guys. Hope so. I'll tell you what are the main important point in this lecture. Okay, first of all, the Competition Act. Okay, what is the actually purpose of making Competition Act, silent feature of Competition Act, what is the anti-competitive agreement, what are the types. Okay, and in vertical agreement it's going to be vertical anti-competitive agreement. We have to understand this part, the types of vertical. Okay, and silent feature is same as of Competition Act and Competition Commission of India. Why was Competition Commission was actually formed? Okay, so these are the main point, and this threshold limit, right, about the merger and acquisition, okay, of value of asset not more than 450 crore and again turnover of 1250 crore. Okay, so up to this, hope so this was little bit benefit to you. Okay, if it was, hit a like button, subscribe my channel, share this video to those who are doing CA, CS, CMA. Okay, those who are CA, CMA, CS aspirant. Till then, bye, we'll meet in our next video.